Okay, we are continuing from our following video. Mhm. But he may retain any such assets for a sum due to him for care taken of them, or for labor expense expended on them, and demand payment of a lien so acquired before delivering them up. Or he may have such sum allow him in accounting for the goods or the value thereof on the trial at law. 17 point P point 449 3RS 5th edition 747. No person shall be liable to an executor or his own wrong for having received, taken, and interfered with the property or effect of the deceased person, but shall be responsible as the wrongdoer in the proper action to the executors and general or special administrators of such deceased person for the value of any property or effects so taken or received, and for all damages caused by his act to the estate of the deceased. In other words, what they're saying is when you've been born, you have a certificate of live birth, and they don't have the word estate on the end, which simply means as soon as you are born, there's another you that's considered to be the straw man, and that straw man is the deceased. So when you up to age and you competent enough, you will take care of that deceased property as the executor slash executrix. Okay. So when you see that word deceased, that's talking about when you've been born. When you born, you wasn't deceased when you came in this world, but it was another you, which is considered to be the straw man, which is that deceased. So you must take ownership of that deceased and take care of all the debts where any claims coming against the estate, which is coming from the deceased, the straw man. Okay. So let me continue. It may be remarked that anyone performing the Christian service of burying a deceased person will be allowed his reasonable funeral expenses out of the estate of the deceased as a debt preferred above all other debts. Who may appoint an executor and who may serve as such? Disabilities, how removed? Disabilities, how removed? The statute assembled amended by the Act of 1848 and 1849 in respect of the rights and powers of married woman provide that all persons except idiots, persons of unsound mind, and infants may devise their real estate by last will and testament. That every male person of the age of 18 years of upward and every female of the age of 16 years of upward of sound mind and memory and no other may give a bequeath his or her personal estate by will in writing. An alien cannot take or give real estate by devise, but his will in regard of personal property will be carried out. The power to make a will involves the power to appoint executors, but 3.2R.693 fifth edition 154, no person shall be competent deemed competent to serve as an executor who at the time the will is proved shall be incapable in law of making a contract except married woman under the age of 21 years. Appointment of executor. An alien not being an inhabitant of his state. McGregor versus McGregor Keys 113, who shall have been convicted of 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 infamous crime, who upon proof shall be adjudged incompetent by the surrogate to execute the duties of the such trust by reason of drunkenness or improvidence, or want of Understanding, McGregor versus McGregor, Keys 133, or one whose circumstances are so precarious, I believe that's how you pronounce that, as not to afford adequate security for administration of the estate, 2RRS 767. Married women are capable of acting as executrix of a receiving letters testamentary as thought they were a single woman, and their bonds given upon the granting of such letters shall have the same force or effect as though they were not married. Chapter 782, Laws of 1867. Before the passage of the act last quoted, letters could only issue to the married woman upon the consent of her husband in writing, filed with the surrogate, and by giving such consent, he became liable for her acts jointly with her. The disabilities arising from the minority of the person appointed is at the end at the arriving of the person appoints at full age of alien on his becoming neutralized or becoming an inhabitant of this state. The first subdivision also include, for example, idiots, lunatics, habitual drunkards in charge of committees, and the disabilities cease in case of the lunatics and drunkards when they are discharged from the custody of their committee and are judicially declared to be of sound mind, are capable of managing their own affairs. Upon the fourth subdivision, it may be remarked that, however guilty or base the executor appointed may be, conviction must precede the objection. And in case of contest before the surrogate, the record of the conviction must be produced. Bob CHR 47 Harrison versus McElhoyne. 1 Brand 289, McElhoyne versus Harrison, 6 New York 443. Emerson versus Bowers, 14 New York 449. The incompetency